Continuing chapter 6 here, book to the right spot. Continuing chapter 6, we already did this, we left off on this slide, doing the easement by necessity when it's necessary to cross over someone else's property in order to get to yours. This is what we call an easement by necessity when the property is landlocked or perhaps not completely landlocked, but partially. In order to get onto your property, you need to cross over someone else's. Then it's necessary. So that's why they call it an easement by necessity for the purpose of ingress and egress, entrance and exit of landlocked properties. All right. Y'all with me, right?
Yes.
Okay. So easement by prescription and adverse possession. Sometimes people refer to this as squatters' rights. It's when you're adversely possessing you're in adverse possession of someone else's property, um, adverse to their title, their ownership. If you're using someone's property for a long enough period of time as defined or prescribed by state law, you could claim ownership of that property. However, you are going to have to sue to make that claim. You don't just automatically become the owner. So this is often referred to as a suit for adverse possession or a suit to quiet title. And then you have to prove that you've been in possession of this property. And there's a couple of other factors that you need to take into consideration. The use must have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, that it's obvious that you've been using it, open, and notorious. So the prescriptive period in New Jersey is 30 years for improved lands. And what's an improvement? Anything that's man-made. It could be a paved driveway, something simple as that doesn't necessarily have to have a structure on it. As long as there's man-made improvements on it, well, then it's 30 years. Or 60 years for unimproved woodlands. You'd have to be in adverse possession before you could make that claim to perfect an easement by prescription. So let's see. Through the process of tacking, successors in interest, such as a landlord and tenant, ancestor and heir, or seller and a buyer, can add on one person's time of possession to that of another, combining them to reach the prescriptive period if they have not been in possession of that property and been using it themselves for that prescribed period of time. So, how can an owner prevent a squatter from taking possession of their property or making a claim of adverse possession? Well, the owner can take legal action against any adverse possessor to get them removed from the property. They could cut off their access. This would stop the continuous use and reset the time clock, giving the owner more time to get them off their property. Or they could give them permission to be there for, say, a day or a week, and then you got to leave. Uh, you cannot claim adverse possession with the owner's permission. One of the things is it has to be against without the owner's approval. So if the owner gave you approval to be there, you kind of reset the time clock immediately, and then you have plenty of time to get rid of that person. There's no way that they'll make that 30 years up as long as you continue to get them removed. And easements by prescription cannot be claimed against publicly owned land, only against private property owners. So let's do these highlights here for easement by prescription. This is page 111. So this is basically just highlighting the same stuff that I had on my notes page there about easement by prescription. Oh, speaking of which, let me open up my notes page to continue doing my updates. All right, everybody got that?
Yeah.
Okay.
Not yet, almost done.
Okay.
All right, done.
All right. And once again, this is the slide from chapter 20 that talked about easement by prescription. And they also mention, well, I give a better description for tacking, what tacking is here. And it gives a better description in a storyline rather than just a rundown list of items in order to claim adverse possession. They tell you that adverse possession is a means of involuntary transfer where an owner can lose their title, their ownership, to another person who has some claim on the land, takes possession, and most importantly, uses the land. In New Jersey, a person may acquire title by adverse possession through the continuous, open, notorious, hostile, and exclusive occupation of another person's property for 30 years, 60 if it's woodlands. After that time, the user could perfect a claim to the land through a legal process known as adverse possession by bringing a court suit to quiet title. And through the process known as tacking, continuous periods of adverse possession may be combined by successive users, enabling the person who has not been in possession for the entire 30 years to establish a claim of adverse possession. Now, those time periods are eventually going to be changed to 20 years. They're going to do away with the 30-year and 60-year time period and make it 20 years, the common law. But until the politicians vote on that, it's still 30 years for improved lands and 60 years for woodlands. So the process is not automatic. Legal actions necessary to perfect the claim of adverse possession. And adverse possession is not possible against publicly owned property. Now, once an adverse user has established title and they proved and got the ownership of someone else's property that they've been using, the former owner has no further recourse. They should have taken action to remove that person so they couldn't make the claim. So to prevent such loss of title, every person having a right to title to real estate must inspect their property at least once every 30-year period and then take action against any adverse claims or squatters on your property. So here's an interesting thing, not about adverse possession, but property owners who feel the government requirements have taken away their rights to use or develop their own property. Because of all the over-regulations and land use controls and government restrictions that they may put in place, the property owner may seek damages under the concept of something called inverse condemnation. Now, the burden is on the owner, who must provide the governmental action has taken away their rights without compensation on how they could use their property. So here is actually a listing I had once. This was in Piscataway. You have a property here. It's a corner lot, or at least it seemed like it's a corner lot. There's actually more grass here on the side, and the road. They were kind of like on a peninsula, and the road goes around them here. And this corner lot is actually owned by the city, and it looked like it was just they had a big side lot, and they're the ones that have been cutting the grass and everything. They even set up a volleyball net over here to play. But I had to make it a point in the listing, when listing the property, that this is not part of the real estate for sale. Only this is. So we don't want people to get the wrong idea. Then they're going to want to start putting up a shed or a fence around this, because that is not part of the lot. And it would come up when they did the survey too, eventually, but I knew it, so I made a point to disclose that right from the beginning, that it's not part of the owner's lot, but owned by the city, but they've been maintaining it and been able to use it since they moved there, because the city hasn't been taking care of it. So the owner cannot claim adverse possession because they've been using it and maintaining it and cutting the grass, because you cannot claim adverse possession against publicly owned property. Now, the owner could go to the city and ask the mayor and the city council if they could issue them a public grant of ownership of that property, and then they'll have to pay taxes on it as well. But it's possible that the municipality could give that lot to them if they did not need it. Why not? It'd make them extra money, and they wouldn't have to worry about maintaining it if this property owner decided they don't want to cut the grass there no more, and they could be a pain in the butt and make the city come out and do it regularly. Here's an example of dedication. Dedication is when a private party gives land to the government for greater public use, like streets, schools, and parks. This is an example of a cul-de-sac street. So this entire lot over here that you see surrounded by the black thick line here, that is one property. But then they're subdividing it into 6 different lots that they could build houses on and then sell. And then they put a street here with a cul-de-sac so you could turn around and come back out. Why would you want to keep that ownership of this street that is on your property? It was built on your property after you sold all the houses. So when this owner gets the plans approved for the subdivision here of 6 lots, to subdivide it into 6 lots and build 6 houses, they should write on that application that they want to dedicate the street to the city. Because you have to note if you want to dedicate it or keep it private. Okay, so what do you call it when the government gives land to a private individual? Where is everybody? Come on, turn on your cameras here. I don't see anybody answering me, and I don't see most of you. So what do you call it when the government gives land to a private individual?
Public grant.
It's called public grant. And what do you call it when a private individual gives land to the government for a public use?
Administrator.
Dedication. So dedication is what you call it when you give land. This has nothing to do with death. You're alive. You just took your lot, you subdivided it, and you built a street. You even named the street. You could name it whatever you want. You could name it after yourself. But but then you dedicate it to the municipality, so now it becomes a city street. So now it's city property, the street, and the city has to maintain it, do the snow removal, any repairs, etc., throughout the years from now on. All right. Anybody ever watch Cash Cab?
Yeah.
It's a show on TV. It used to be. Well, you can still find it on the Game Show Network every now and then. It was a great show. It was on for years. It's basically a comedian. He created a game show where he was also a taxi driver. You know, that's the way a lot of comedians, they got to have their side hustle until they make it, right? So he decided that he was going to turn his side hustle into the main hustle. He was going to combine them. So he took his job as driving a taxi and turned it into a game show, a trivia game show. When people got into his cab, they closed the door, he'd hit a button, and all the ceiling would light up like crazy, and it'd make noise with the speakers and stuff. And he'd say, "You've just entered the Cash Cab. It's a game show that takes place right here in my taxi cab." And he's going to ask them random trivia questions, and they could have an opportunity to earn money for every question they get right, and they progressively get as the rounds progress, they could earn more money for each question. But you get 3 strikes, and he pulls over wherever you're at and kicks you out of his cab, and you get nothing. So he asks people if they want to play, and then he goes from there. So it was actually a pretty entertaining show. If you get an opportunity, catch it. But here, I got a couple clips that I'm going to show you from that I saw were real estate related. So let's have at it. Let me see if I could get this volume through the share my computer sound directly with you. And let's see if you could hear it better, because I know the recording's a little crappy. Let's see if you guys can answer this question, a trivia question yourselves. Ready? Here we go.
What term?
Whoop, I need to crank up the volume. Hold on, give me 1 second here. Rewind that.
What term for a dead-end street means bottom of a bag in French? Ooh.
What term for a dead-end street means bottom of the bag in French?
Cul-de-sac?
Ooh. Is it cul-de-sac? I'm afraid it is. Cul-de-sac is correct.
There you go. You just won an additional $50 if you were on the Cash Cab. Okay, so
what term?
Let's see. There's another one we got here for you. Let's see if you get this one. Yeah, I'm gonna try to crank it up a little bit more. I know it was kind of quiet. Okay, are you guys hearing it fine, or is it really too quiet?
Yeah, it sounds good.
Okay. Oh, it did sound good? Okay, cool.
These next questions are worth $50 each. What Chinese spatial philosophy is used to determine sites for graves and house design?
What Chinese spatial philosophy is used to determine sites for graves and house design? Anybody? Come on, the time is ticking. There's a clock.
No idea.
These next questions are worth $50 each. What Chinese spatial philosophy is used to determine sites for graves and house design?
Feng Shui.
That is correct.
It was feng shui. See, it's an entertaining show, right? Wish that was still on the air. I used to watch that all the time. It was a pretty good time waster. And you see how the cab, all the lights light up, and you get the sound effects going on in the background.
These next questions.
All right. Anyway, easement. Continuing with easement by prescription here, we have lot owner A and lot owner A on the left, lot owner B on the right. Both have houses on their lots, so they're improved lots. How long does somebody have to use the other person's property to gain adverse possession?
30 years.
30 years. So in this case, the property line is right here, but where you see this red dashed line, there's a fence. Now, we don't know who put the fence there, if lot owner A put the fence there, or lot owner B put the fence there, or a previous owner of one of those lots put a fence there. But either way, it's clearly over the property line. So if lot owner A has been actually using all this property up to the fence, and lot owner B finds out that, hey, wait, my property line's actually right over here, what can they do to prevent lot owner A from claiming adverse possession? They could take A to court to get them to remove either the fence or to stop using the property over the property line. They could give permission for them to use the property there with the knowledge that this is their lot owner B's property. Or they could cut off the direct access by putting a fence where it actually belongs on the property line. Now, how did that fence get there? We don't know. Maybe it was lot owner B was just being a nice neighbor. They weren't sure exactly where the property line was, so they put it in their property a little bit. But that doesn't give A the authority to then start using their property because they put the fence inwards of their property, not directly on the property line. Or lot owner A could have put it there over the property line. We don't know. But sometimes these arguments come up, and they could have been done by previous people years ago. We don't want to assume who put it there, right? Because you know what happens when you assume, right? This is the late, great Benny Hill. Whoop. It'd help if I took the mute off. So this is a little clip here from the late, great Benny Hill. Let's try that again.
You must never assume, because when you assume, you make an ass out of you and me.
You know, but that guy was a trip. I don't know if you guys ever seen Benny Hill. He was a hilarious comedian. Him and his father, a little guy, bald guy, used to tap him on the head and kick him in the butt a lot. He was before his time as a comedian, though. Okay, so we're going to talk about boundary line disputes. Don't assume who placed that fence there. It could have been a previous owner, the neighbor, etc. So don't assume, because when you assume, that's a great line. Okay, so now I'm going to have an attorney here explain. She specializes in land issues like this. So she's going to explain how adverse possession works. Whether it's a farm or if it's in the city, she's going to explain the law so you get a little insight from the attorney's standpoint on adverse possession.
For an attorney or for just a property owner, I think.
I am sorry, this recording, I cannot really improve it. This is the way that it was. The best I could do is jack it up a little bit and try to pipe my speakers directly through Zoom to you, and hopefully you guys can hear it decently. Let me know if you're having trouble hearing it at all, though. Let me move those Zoom controls out of my way.
A lot of times people don't even realize that this body of law exists. Maybe when you own your first home or you get your first survey, you start to realize how important boundaries can be. My name is Jessica Shrestha. I'm an attorney at Wheeler, Van Sickle, and Anderson. That's here in Madison, Wisconsin. The concept of adverse possession is that, well, first everyone has a deed to their property. There's a legal description, there's a boundary, whether it's a lot or something else, specific distances, and that's your boundary. But as everyone knows, it's hard to figure out where those are, and a lot of times actual occupation on the ground doesn't necessarily match the real boundary lines. Sometimes it's a matter of a few inches, but sometimes it gets to be, we're talking feet, acres, a whole 40-acre parcel sometimes. And it turns out that if you occupy and use an area of property for long enough and treat it as your own property, the doctrine of adverse possession makes that your property by law. It's more complicated exactly how that applies, but that's the basic concept. Over time, property can become yours even if you don't have a deed. that describes it. Adverse possession comes up most often for a typical property owner with a fence. That's really the classic example, and that has been for as long as we've had, real property and the law of adverse possession. Someone will construct a fence, and even if they get a survey to tell them exactly where the property line is, they might construct their fence a foot inside their property. They want to make sure they can stay on the other side, for example, or a foot on the other side. Sometimes it's a greater distance. And over time, they forget, or maybe they didn't know where the exact boundary was in the first place, and that fence might become the boundary by operation of adverse possession. Same thing goes with lines of trees and hedges, or even people might place a shed on a neighbor's property. And that's in a city lot. The same thing, though, can happen with pasturing cattle or with fences for cropland. When a client or a potential new client comes to me and they think they have a boundary dispute or maybe an adverse possession situation, to start, I think the easiest way to think about it is you have to ask the basic questions: the who, what, when, where, why, and how. The who is really important. Who are the parties involved? And with adverse possession, it's not going to just be the current property owner necessarily. Do you have a governmental entity? Who owned that property 20 years ago? The what sort of property is involved? Is it hunting property, a city lot? Those are important things to know about property and deciding if you have adverse possession. When? Are we talking 20 years of adverse possession? Was it occupied between 1930, 1950? What time period? Where? How much property is involved? What is the actual boundary line that's in dispute? And why? There's a recent case, again, Wilcox versus the state of Hines, that told us it is important why you were possessing the property. Did you intend to possess it? Was it with the permission of the true owner? Did you think it was your property? And then very importantly, how? What were your acts of possession that constitute adverse possession? When I have all of that information, I sit down and I think, does this equal adverse possession? I compare it to the case law. And then I start to think about possible defenses and different related doctrines maybe that could come into play, such as the doctrine of acquiescence or easements. Attorneys should know that the statute isn't going to answer their question in most cases. You need to look at the entire body of law that has developed over time. The adverse possession statutes actually codify the common law, and so there are different elements even in the cases than ours are listed even in the statute. So the elements of adverse possession are continuous, exclusive, open and notorious, and hostile possession, whereas there is no reference of most of those terms in the statutes themselves. Attorneys also need to know that you shouldn't just look at either the first case or even the last case. It's been a long and complex doctrine that has evolved over time. And a good place to start is probably the latest case, but there are plenty of cases from over 100 years ago that I still reference and that are still relevant good law that you will need to be aware of. Part of why I wrote my article is sometimes it's really hard to find a good summary of adverse possession law. A lot of the treatises will have it, but that's on a nationwide basis. And our state, along with a lot of other states, has developed the law in its own way. So I think the best way to sort of follow along and know what you should be looking at is to just go through the cases. You're going to have to do your case law research. Hopefully my article will give you a good starting point, but from there you just have to get into the topic.
There you go.
For an attorney,
Let's see. Let's look at criminals now. They think they become these online attorneys, right? They get their education from YouTube and social media. Let's look at some of these cases.
A bit more bizarre business story. We're going to talk about the headlines about the young man who moved into a $2.5 million mansion near Miami without paying a dime. We first told you about this story Friday morning, but we're now learning that this has become a national trend, and some of the people doing it are even connected to an anti-government group the FBI classifies as domestic terrorists. Boca Raton, one of the poshest zip codes in Florida, is abuzz this morning over what is happening inside this $2.5 million, 7,500 square foot waterside mansion. The bank foreclosed a couple of years ago, but now a 23-year-old named Andre Barbosa has simply moved in.
Nobody's happy. We all spent a lot of money to live on this street.
Barbosa is using an obscure legal concept on the books in every state called adverse possession, which says if you live in an empty home for a certain amount of time, it's yours. Adverse possession is being attempted all over America. Susan Weidman took over a series of homes in the Atlanta area.
I filed adverse possession back in February as Susan Weidman at the DeKalb courthouse. So I'm not just, transient squatter here.
This $3.3 million house near Raleigh, complete with an elevator, got caught up in this whole mess when Sean Pendergraft claimed he owned the house.
It's not a scam. Everything we're doing is lawful.
There have always been squatters, but the housing crisis has put the phenomenon on steroids. Some of the people using adverse possession are connected to a sometimes violent anti-government movement known as sovereign citizens, who believe U.S. laws do not apply to them.
A police officer walks up to someone who is claiming a house now belongs to him without any basis at all, is handed a big sheaf of documents which are incomprehensible. And I think very often the officers ultimately feel that they're forced to go back to headquarters and try and figure out what's going on before they can actually toss someone in the slammer.
I met a young sovereign named Robert Peterson who moved into this foreclosed home in Idaho.
They're the enemy. They're the enemy of anybody who wants to live free.
One expert on sovereigns found evidence to suggest that Andre Barbosa, in that mansion in Boca Raton, is connected to a sovereign group called Divine Province, based on the language Barbosa used to justify moving into the mansion and the fact that his name is on the group's website. Before you get any ideas about trying to use adverse possession, consider that the sheriffs forced Robert Peterson out of this house, and remember Susan Weidman, arrested for racketeering. And Sean Pendergraft, also arrested for obtaining property by false pretense.
All the legal arguments he may make or the documents he may file will all end up leading to the same conclusion, and that is that he gets kicked out because he has no legal right to be there.
As for Andre Barbosa, he may be running out of time in that mansion in Boca. Bank of America has now filed a claim in court claiming it is the rightful owner of the home.
It's so crazy that they're arguing that the law's on their side.
They are, and they're kind of 1/3 right.
Fascinating story. All right.
Well, you can't be 1/3 right with the law. You're not going to get anywhere with that. And I do have videos, but I'm not including them in this class of the follow-up of what happened with our Andre Barbosa. Police ended up swarming the house to get him out of there and turn it over to Bank of America after a judge ordered so. But when they got there, he was already gone. There was only a couple of his possessions there, and so they just moved them out.
A bit more.
But here's another example.
Now a warning about the risks more and more people are taking to get a house for next to nothing. It's an obscure law some hope to cash in on, but often land in jail instead. Our Chris Trankman joins us live in Polk County to explain more on this. Chris?
Well, the sheriff says some people never learn. This is the...
Oh, by the way, the sheriff, this is in Florida. Which, by the way, in Florida, the period for adverse possession is only 7 years. But where New Jersey, for improved lands, it's 30 years. This sheriff is a trip. You guys may have seen him on TV or social media before. This guy is a trip. He's like a comedian. He's funny, but he's direct and he's firm. But he's a trip. I like this guy. Sheriff Grady, I think is his name.
House in question, it's valued at $160,000. It's in foreclosure, and both deputies and residents here are baffled why a couple thought by breaking in, turning on the power, water, and cable, they would have the right to own the house without paying for it.
With the homes being vacant, it just takes neighbors in the neighborhood having their eyes and ears open.
Danny Rodriguez says residents along Echo Lane noticed a locksmith changing the locks and moving trucks unloading furniture into this vacant house. As the Homeowners Association president, familiar with his neighbors, Rodriguez suspected a scam.
I knew a little bit about adverse possession just from doing some research at saying you need to be in the home for 7 years, and I knew they weren't here for 7 years.
Adverse possession is a Florida law from the 1800s that applies to unoccupied farmland. The property appraiser alerted sheriff's deputies about Sherry Fields and her husband after they filed for the obscure law. They were charged with burglary and grand theft. Meanwhile, Sherry Fields is a teacher at Fort Meade High School.
Come on, girl.
You know, you got a college education. You should know better than that. But anyway, we gave her a field trip to the county jail.
Sheriff Grady Judd says more people are learning about adverse possession from websites online, mistakenly thinking they can use the law to take over an unoccupied house for free.
Of course, we all know if it's on the internet, it's got to be true. Well, what they didn't see on the internet was my Facebook page that says, "We will put you in jail."
You know, we work hard for our homes and what we have, and it's not fair for someone to just come in and take somebody's possession like that.
And the sheriff says the school teacher and her husband are going on another field trip, this time for a crash course on Florida law. They'll be in a courtroom tomorrow. We're live in Polk County. Chris Trankman, ABC Action News.
See what I mean? That sheriff's got a personality, right? He's a trip. Come on, girl. You know better than that.
Now a warning about.
All right. Let's see. What's this one?
Caught in the act, how one woman stopped a group of squatters from moving into a vacant home she owns.
All right. Now, this one could possibly turn into adverse possession if you let it get that far. But the thing is, sometimes getting people out of your house, even when you catch it in time, may not be so easy. Especially, this is an example in California, but New Jersey's a very liberal state as well on how we craft our laws here, and we often follow suit of California as the testing ground, or Illinois. And in this example, you're going to see New Jersey law is very similar to this. So this is why I'm showing you this, because this is also possible that this could happen here.
Good evening. I'm Jackie Parks.
And I'm Todd Carley. 23 ABC's Mark Christian is live tonight from a home in Oildale where those squatters were trying to take up residence. Mark?
Well, guys, if you think if someone is living in a home illegally, it'd be a simple case to get them out. Well, squatters move under the radar to try to move in very fast, and in some cases even changing the lock so they can move in before the owner finds out.
I saw like about 20 people at my property trying to move in as fast as they could.
After her previous tenant moved out, the home had only been vacant for 10 days.
Unfortunately, some of these squatters have gotten pretty sophisticated.
Rena Chanty was getting her home ready to put it up for rent when a neighbor called to tell her someone was trying to move in. The squatters were moving in a refrigerator, a washer and dryer.
Basically everything a house needs. They were even putting up their decoration pieces, and they had changed the locks.
When deputies arrived, the squatters were still in the process of moving in. Though not commenting on this specific case, Ray Pruitt with the Sheriff Department says squatters can take refuge under the California tenant law and have even been known to falsify rental agreements.
Once they're in that.
So New Jersey is very similar in that when it comes to residential properties, where the law is on the side of the tenants, because the tenants are considered ignorant and they're not as savvy of the law as a landlord would be. On commercial real estate, it's the opposite, because business owners are the ones that are renting the space, so they could be more savvy as well, so they don't need the protection of the state. So the courts tend to side more with the landlords on commercial properties. But let me back this up again just a little bit. Here we go.
Once they're in that property, in some cases, it's very hard to get them out of that property without legally evicting them.
In cases like this, law enforcement's hands are tied, because if the squatter presents what appears to be a legal agreement, it comes down to he said, she said.
Sometimes we can't determine if the squatter's in the home legally or not.
They know the system and they know how to play the system.
Fortunately for Chandy, the squatters did not get that far and could not provide any documents to law enforcement.
At that moment, the cops told me it was my word against their word, and I had to prove that I owned the property, which I had the paperwork on me.
So right now, Chandy is checking her house daily until she can officially get it rented. In the meantime, she's asking her neighbors to keep a watchful eye until that place gets rented. Back to you, Jackie.
Wow. That's some chutzpah there, huh? Trying to just break in, change the locks, and take over someone else's house. Jeez. if these criminals actually use their minds to do good, they may actually be successful people in life. You know, it's amazing how some of these people that are criminals, they got a decent mind, but they don't use it for good. They use it for crap like this. All right. Here's something else. Like, we used to see this stuff all the time on. I even had this happen to me one time where I had a listing for a rental property, and you know, you put it on the MLS, it syndicates out to other websites, but then I manually placed them in websites too, you know, like Craigslist and other people, places like that, directories. And I once found out somebody stole one of my listings, you know, the whole write-up I even did, had my contact information even on there, but they put their own contact information in the one section as well, and they were trying to rent out one of my old listings. They were trying to, I guess, scam somebody to get deposit money and the first month's rent, maybe even meet them at a property and give them keys, you know, and then disappear because they're not really the rightful landlord, but they try to rent out other people's houses, pretending to be the owner.
Well, how come you're running away from me? If it's all legal, stay and talk to me. There may be a good reason why this guy didn't want to stick around or explain how he helped two families move into this Coconut Drive house. Terrence Smiley tells me this man he knows as Encino Hernandez offered a deal on this house that was too good to pass up.
He say he have a house. Go check it out if you want it. We can do business.
Turns out the guy dashing off in a hurry doesn't own the house, but Smiley says that guy offered to rent the house to Smiley for $500 a month. The guy denies that. He claims he just
$500 a month for the house. Come on, something. Yeah, if it's too good to be true, it probably is.
charged Smiley $190 for advice about a form available at the property appraiser's office and a little-known law called adverse possession. Adverse possession allows someone to take ownership of abandoned property if they live on it and pay taxes on it for 7 years. What's happening in the Bay Area is a lot different. An 8 on Your Side investigation found some people are turning the adverse possession law into a money-making scheme, taking control of vacant properties and then renting them out.
Do you believe that you've committed any violation or crime or misdemeanor? No.
That's what Steve Bible told me more than 3 years ago. He moved 31 families into homes he didn't own.
By the way, I've seen people like this on YouTube teaching courses on how you could become a real estate mogul through adverse possession. Basically, they're teaching you to break the law to make money. And, you know, I reported this many videos. When I stumble across these, I report them to YouTube as breaking the law. But YouTube in every single instance said it's not a violation of their terms of policy, which drove me nuts at the time because, God forbid, I made a comment that YouTube didn't like because of maybe a political view or standpoint or something. They would, you know, you get the ban for 30 days or whatever it is, but you get these guys that are coaching people on how to break the law. It's not against YouTube's terms and conditions, and they don't remove these videos, which is just insane to me.
Filed adverse possession papers and collected monthly rent. He's now in prison, serving 5 years for fraud. The Hillsborough County property appraiser tells me there's been an explosion of adverse possession forms coming through his office in the past few months. So we set out to find out who's filing this stuff. We visited house after house after house, all of them listed on adverse possession forms we obtained from the appraiser. Most are vacant. But at this townhome, Alice Fugate had a big surprise after she signed a lease with the real homeowner.
We had squatters in here the day before we moved in.
These new renters found other people's stuff inside. And 2 doors down at another home on the adverse possession list, we found a cable TV installer waiting to do his job.
They can stay there if nobody kicks them out.
Stetson Law professor Daryl Wilson says adverse possession is a technically legal way to take over abandoned property if the right steps are followed.
You would think that the person who owns the property would come and police their property. The law helps those who help themselves.
Where we draw the line is breaking it.
That's a bottom-feeding attorney right there. Yeah, law helps them. It's like he's justifying people breaking into your house and squatting in your house and using it because you weren't there. Yeah, imagine you go on vacation, you post on Facebook, your vacation photos and how you're having a great time in Acapulco or wherever the hell you went, on vacation. And somebody sees that and they see that you're not home. They find out where you live and then they break in and take over your house. The law helps those who help themselves. What the hell is that? Yeah.
Into somebody's home.
But the Hillsborough Sheriff's Office takes a hard line on adverse possession.
It belongs to somebody, so stay out of it. If you go inside of it, you break inside of it, we're going to arrest you for burglary and theft.
So you the landlord here?
No, I'm not.
Then why'd you rent it to these guys?
I didn't rent it. They went down to the courthouse and did that.
This guy tells me he doesn't charge people like Terrence Smiley rent. They just pay him for his adverse possession expertise. He later agreed to talk to me, but the phone number he gave...
The mobile number you have called is no longer in service.
These tenants could end up in the cold. Detective McKinnon says the sheriff's office typically gives renters in adverse possession cases 30 days to move out.
Innocent families, it's just bull crap, man. Really bull crap. You work hard for your money.
In this case, and so many others, adverse possession adversely affects people's lives. Peter Bernard, News Channel 8.
Yeah. Now, when it comes to property line disputes, we're done with adverse possession here partially. This is a property line dispute. Once again, another case in Florida, but this thing is pretty wild. You know that when you're going to build a house, there's certain zoning regulations. You've got a property line. When you build a house, you have to have a setback, what we call a setback. A setback is the minimum distance from the property line that a structure can be built. So you have a front setback, which is usually the greatest, and then you have side and rear setbacks, which is off the property line you need to build a house. But what do you do when somebody builds a house and then they get the land subdivided afterwards, and then they get foreclosed on, and then it was all done wrong to begin with? And you could run into some serious issues. In this particular instance, you have a real estate agent now involved, and she lives across the street. And I think it was her listing at one point, and she's all bent out of shape because she wasn't able to sell it because somebody who bought one of these properties at auction was standing up for his rights because he tried to get a permit to build a house, but he was denied because the lot that he has is too small to build a house on because of the way that they subdivided this property and built it. Now, the guy tried to get permission to get a variance to build a house on a smaller lot than normally allowed, and then it would have been fine and he wouldn't have disturbed the neighbors whose house was actually built over the property line on his property that he bought. So you tell me if you think this guy's well within his rights to put up a fence the way he did and protect his property to prevent any claims of adverse possession.
This is a wild story. New from Orlando, there are big questions tonight about what is going to happen to this house in Wadeview Park now that a boundary dispute has reached a whole new level. Check out this new fence. It splits a pool in two. Channel 9's Shannon Butler is live there in downtown Orlando. It's just south of downtown. And Shannon, this fence has neighbors scratching their heads and wondering what will happen next here.
Yeah, if you walk down this street here in Wadeview Park, it looks normal, right? There's a house on this lot. There's no house on this lot. But if you look behind the bushes here, you can see the guy without a house has put a fence on the guy with a house, making it clear where the property lines stand. Now everybody is asking, what's this guy do now? This home along Harding Street sat vacant for years, all because of a boundary dispute. The MLS listing says, quote, the pool and the garage are partially on the adjacent parcel and not included in this sale. Huh? It's such a mess that realtors don't even want to touch it. This realtor posting about it saying, quote, "My job as a realtor is to help people buy and sell properties. Sometimes my job is to help people not to buy." So the house was just sold at an auction, and now what was a dispute has been taken one step further. The owner of this lot seemed to have put up a fence right through the pool of the other guy's lot, splitting the garage and that pool in half.
That's where we stand now. We have a brand new owner of this house, and this is how they choose to make their statement to the new owner.
Lisa Sconyers is a realtor and has lived across from the two properties for years. The history is long and sordid, but the easiest way to explain it is that both lots were owned by the same person, a house on each. He then sold them to the new owner, who then cleared the lots to build one big house. But that owner went into foreclosure and the lots were sold to two different people. So now this house is over the property line of the other lot. In the end, Sconyers says this could have all been avoided.
The city of Orlando didn't permit this the right way. What they should have made these people do is they should have made them replat the property into two separate properties. They never did that.
Now, we have reached out to both sides and the city. We're still waiting to hear back. Now, when it comes to this property here, this property owner is trying to get a petition. He's gone around to the neighbors, asking the neighbors to give him an exception to back it up because this lot isn't big enough for a house, to allow a house to be built there. Now,
So he's asking for a permission so he could file for a variance to build a house on the smaller lot. And if he gets that permission, then he doesn't need to. He could take that fence down and let them people live their lives and whatever, and just deal with having a smaller lot because he got the permission to build a house on a smaller lot. However, he's getting some static from that neighbor, the realtor across the street, who actually took this as a listing and advertised it that way, that the property's partially on the other lot.
the neighbors are saying, I don't know if I can back you on that because you asked us to do that before you did this, and this problem still isn't solved. We're live in Orlando. Shannon Butler, Channel 9 Eyewitness News.
It's an interesting case there.
This is a wild story.
That's pretty wild. So what is a party wall? A party wall is a common shared wall that separates two properties. It could have been like a brick wall fence, or made of stone, like in the Middle Ages, they put up stones, stone walls. But here we often today refer to as a party wall in shared housing, like townhouses and condominiums that are separated by, each unit is separated by a wall. So that is called a party wall. And each party is responsible for maintaining their side of the wall, because if the wall crumbles and falls apart, then neither one of them has a wall. But either way, that's the basic gist of what a party wall is. It's a wall of a building that straddles the boundary lines between two owners' lots. That's on page 111. You guys got it?
Yes. Got it.
Yeah. Let me grab that now too. Party wall.
I have a lot of stories where my father had clients where they wanted to put a fence, and then the neighbor comes out and they tell us, no, the fence of the fence is
not on their property
here. It's not on our property. And then like they actually come out right when we're actually putting up the first two panels of fence.
Yeah.
And then the neighbor comes out like, no, put that back over there. And then we were like, no, like the owner said that this is the line of the property. No, it's over here. Like go further. Like
that's why owners, they should get permits for that first and get a survey. They need a survey for that. If you're putting up fences for people, it's not a bad idea to get a metal detector. I'll give you a tip why. you get a metal detector and look around the areas where the corners of the properties should approximately be. And there's probably a steel piece of iron stake that is banged into the ground and is probably a couple inches beneath the soil. And you get a metal detector, it finds where that is, you dig it out, and you could see where the stake is, where a previous survey was done, and that's one of the corners of the property. On the other corner of the property, you could tie a string between the two, and you could see now where the property line was based on that survey, provided that nobody moved those stakes, which I doubt they would have if you see it a couple inches beneath the surface, beneath the grass, It's not a bad investment. You can get them pretty cheap. They're not that expensive to get a halfway decent metal detector. Trust but verify what the owner says, before you go ahead and do it. Otherwise, you're gonna have problems with neighbors, while you're putting it up. I mean, it's really not your issue as much as it is the property owners. You could put up a fence though, and if they now have to take it down, if you didn't catch your payment from them first, they may be giving you issues to come back and take down the fence and move it now. Now you're doing twice the work, So that could be, right? So it's not a bad idea to try to trust but verify the information that they've provided to you where the actual property line is, because often they don't even know themselves. Ask them if they got a survey even. But get that metal detector. I'm sure it'll save you a lot of headache. Hell, you can get them on Temu for like $50. All right, licenses. A license is permission to enter the land of another for a specific purpose. Licenses can be revoked at any time. They're usually verbal and not in writing. An example that I've given before is a neighbor gives you permission to come over their house and use their pool. They've issued you a license to do that. And then you get into an argument with the neighbor. They don't want you on the property anymore. They can revoke that license by just saying, I don't want you on my property anymore. You can't use the pool anymore. It's as simple as that. Licenses are not that complicated. They don't need to be in writing. And that's it. All right, so let's just do that highlight. All right, licenses can be revoked. Oh, I think you guys already have that highlighted, right? I think I previously told you guys. Mhm.
Can you give an example of a license again?
License is permission to enter the land of another for a specific purpose. It's often verbal and not in writing, and they could be revoked at any time. The example I gave is, say you're my neighbor. I say, hey neighbor, feel free to come over to my house and you could use the pool. Even if I'm not at home, you're free to take a dip if you like in the pool and cool, right? So just being a good neighbor, and I give you that invite. And then at some point, we get into an argument over something, and I say, I don't want you on my property no more. You can't use my pool no more. I just revoked your license. So when I gave you permission to enter my land to use the pool, I issued you a license. When I told you I don't want you on my property no more, I revoked that license. It's as simple as that. And it can be for various things.
Thank you.
You're welcome. All right, so here on this slide, we have parking licenses, easements, encroachments. We have the definitions of all those items here. So let me get this. It's interest terms. Get all those definitions. Once again, it's a shared common wall on attached housing or a wall separating two properties. There's usually a party wall agreement in place that states that each party is responsible for maintaining their side of the wall so that the wall does not crumble. And then we don't know where the property line is anymore. License is permission to enter the land of another for specific purpose, and licenses can be revoked at any time. They're often verbal agreements. They do not necessarily have to be in writing. Easement is a right to enter someone's land. So the difference between a license and an easement is licenses are permission, and permissions can be revoked, and a license is a right, and once somebody's been given rights, they can't be taken from them. So an easement is a right to enter someone's land for a particular purpose. It's often added into the deed itself or the survey. It is a right, and rights cannot be taken from you. They can, however, be given up. You could give up your rights. The dominant estate is the one that benefits from an easement, so they could give up their rights. So let me see this writing here. So they can, however, be given up. You could give up your rights. Dominant estate benefits from an easement, so they can give up their rights. The servient estate cannot take them from you. Once they give you an easement right to enter their property, they cannot be taken away like a license can. And encroachments. An encroachment is anything that crosses over the property line, like a part of a building, fence, driveway, anything that crosses over the property line. Fence or driveway or other installation that illegally extends beyond the land of its owner onto the neighbor's property. Okay, that is an encroachment. So encroachment, if you look at it, it has the word roach in it. And much like a roach, it's something you don't want on your property. That's a little saying that one of my students gave me, so to try to remember it. But that's what it is, basically. Anytime an installation illegally extends beyond the land of its owner. Now, you may start asking me questions about, well, what about trees and bushes and things of that nature that cross over the property line? Well, I'll tell you, if you got trees or bushes, something like that, that crosses over the property line, those are by nature. Those are not installed by man, right? It's installed by Mother Nature there. And anything that's on your property or crosses over your property line, think of it like an invisible wall that extends up. So if a tree has branches hanging over your property line, you can trim those tree branches that are hanging over your property line. Now, if you got a tree stump, the root of the tree is on both properties, that gets a little stickier, because you could kill a tree and you better go to court over that, or have a judge render a decision what could be done there, or call the city and ask them, because that gets kind of sticky. So seek legal advice for that. All right, creating an easement. How do you create an easement? Well, by express grant of permission by the property owner, by a deed conveying the real estate, creating an easement over that land that was sold, granting the new owner an easement over the grantor's remaining land, by long-time usage, via an easement by prescription. However, this easement must be perfected in a court of law with a suit for adverse possession.
Teacher,
yeah,
I have a quick question.
Yeah,
so I'm over here thinking about, like, okay, so they could stay with the property after 30 years, right? Like, how do they pay the taxes if they don't own the house or the property?
They don't. The owner's still
Oh, they
paying.
don't.
The owner's still paying the taxes on it.
Oh, okay, okay, I get it.
But the thing is, this type of easement is created by your occupation of someone else's land. So you really don't care. Right? You're a squatter.
Yeah.
You're trying to sit on someone else's property and claim the ownership of it. Which that's pretty messed up.
Yeah. Well, thank you.
That's one good part of Florida's stand your ground laws. You know, you got trespassers that come on your property and won't leave. You could shoot them. You protect your land, your property, your family. You know,
I think that's a thing in Texas where I don't know if it's true, but someone told me that in Texas, like if you have a belief that somebody is trespassing your property or trying to steal something from your property,
Yeah.
and you know you're like if let's just say your dog, or if you have a weapon, whatever, and if you actually like kill that person, like and if the police comes, that's considered like not like
it's
like
self-defense. It's defense of your property. Look,
yeah.
this doctrine dates back to the days of cattle rustling. You know, when you got cowboys. You know, everybody was a cowboy back in the day when this country was being formed, pretty much, right? There's a lot of horses were the main means of transportation, and then you had your cattle. You know, you've had your donkeys, you've had your bulls, you had your cows, you had all that. That was your living. That was your that was everything to you, right? So if somebody tried to steal your cattle, that was a hanging offense. They could play the judge and jury and executioner right there on the spot. And it works kind of the same way today. It's called the Stand Your Ground law, and some states have these. And some states have them. Look, New Jersey even has a stand your ground law, except it was kind of perverted by some political ideology thinking. Okay, let's just leave it at that. So it was kind of really perverted, and it basically makes you the homeowner. If somebody breaks into your house and they see you there standing there with a gun and they try to run from you and they turn around and you shoot them, you could actually be in trouble because they were a case could be pled that they were fleeing your property. So the property owner, actually, it's advised in New Jersey and some other very liberal states, the stand your ground law was kind of perverted to the point that they tell you as the property owner, it's your obligation to run away. That's not stand your ground. I don't know how they could consider that stand your ground by running away. You protect your family, your life, your property, even to prevent people from just being bullies now and knowing that the law is not going to protect you. So they come in and they push their way around to get what they want. You see this madness happening everywhere right now, right? Because you had so many people that crossed over the border. There was a lot of gang members and bad people that came over the border along with the good people, the well-meaning people, right? And those people, they don't give a crap. They don't care about you, your life, or anything. If they want to have sex, they'll rape your wife or your daughter, and then kill them so there's no witness. These people don't care, so they could care less about your property, I don't know. Even though I live in New Jersey and we have this perverted stand your ground law, somebody breaks into my house, you're getting shot. I'm a proud Second Amendment supporter, and that's Second Amendment was put in place to first and your property rights. So what you do, though, that's up to you. You look at the what was it, chapter 3, where we were talking about realtor safety and all those videos I showed you, where these realtors were attacked and such, then all of a sudden, even the old lady, all of a sudden now she carries a little extra protection in her purse, you know, and then she pulls out a gun, which makes me laugh because these people are probably like, oh, Second Amendment, anti-gun, until they get cracked in the head and they get stitches and they feel like they're gonna get murdered, you know. Then all of a sudden, crap just got real, you know. So forgiveness is one thing, but when it's down to it, and you know somebody's coming after you, that's a different story altogether. Okay, but anyway.
So Victor, one quick from my side. I am receiving $89 unclaimed dollar from New Jersey state.
Hey, that's $89 you didn't have before, right? That's hey, whether it's a large amount, that's $89. Hey, that's in New Jersey, that's maybe what, half a tank of gas?
Yeah, well, $89 is $89.
With your electric bills going up, you're going to need that.
Yes.
Yeah, I told my friend I just got my electric bill, and my electric bill was only $157. So I told you my friend called yesterday and asking about did electric bills go up already because his electric bill was $450. I thought it may be because of maybe his pool pump running all the time, but this was another house he has where that bill was so high. It wasn't that house. So I told him, you know, you got to do like an energy audit or something. Maybe your HVAC system is got a problem and it's using more drawing more electricity or something. I don't know. But that's an extremely high electric bill for a single family house. You know, I thought it was his 2-family house where he also has a pool and stuff there, you know, but it wasn't. So you're going to need that money. Invest it. Don't spend it all in one place. No, okay. Go out, have a great dinner. Enjoy. Anybody else find any money from Missing Money, New Jersey's Missing Money website or the national one? Anybody look?
My father, well, he did not receive the instructions yet from the website about what's the next procedures, but he did claim to like properties, 2 missing money cases. Yeah.
Oh, okay, great. Yeah, he's got something coming to him. That's awesome.
I found some for my mom as well.
Look at that. 3 people. 3 people. That's awesome. I love that. I love it. And so let's continue here. So the other ways that you could create an easement is by long-time usage through easement by prescription or by necessity, when it's needed for the purpose of ingress and egress to get access to get on and off of your landlocked property, or by an easement in gross, which is a public utility easement. They could ask the owner for permission, or they could just take the land if it's needed for a greater public good with just compensation. And it's paid to the owner when they take your property by eminent domain, right? They did that along Route 1 and 9 along from Woodbridge to Edison when they widened the highway several years back. They added another lane in Woodbridge and Edison, if you guys recall back then. And all the storefronts along the one side of the road, they took like 10 feet so that they could add another lane. And they also took a couple buildings. I think there was a single-family house or multi-family house, and there was a couple of businesses. They took those buildings by eminent domain so that they could put in those clover leaf turns. You know what I'm talking about? Where you got to go, if you want to make a left turn, you got to turn to the right, go around, and then cross the highway instead of making a left turn on the highway. So they took some properties by eminent domain there. All right, so terminating an easement. How do you terminate an easement? Well, when the purpose for the easement no longer exists. However, that one only applies to an easement in gross, the utility easements. You may want to write that there after that one on the page 112. Is that on page 112? Yeah, page 112. When the purpose for the easement was created no longer exists. That one only applies to an easement in gross. Or when the owner of either the dominant or the servient tenement becomes the owner of the other, because you don't need an easement to cross over your own land. By release of the right of the easement, you could give up your rights. They can't be taken from you, but you could give them up. Or by abandonment. However, I elaborated here a little bit. Courts have ruled that simple non-use of a property does not constitute abandonment of it. You would have to prove the person's intent was to abandon that easement right. I remember when my dad was alive, he owned land in Pennsylvania. He grew up there, you know, and he was like, one of these days we're going to move back to Pennsylvania. Like, he talked about it his whole life. He never did, but he talked about wanting to do so his whole life. But the neighbors over there, I'm sure they thought the property was just abandoned, you know. So courts ruled that simple non-use does not constitute abandonment. You have to prove it's the person's intention to abandon it. Like in my father's case, that was the furthest thing from the truth. He wanted to go back there. He just never did. But that's where his final resting place is. We brought him back home. All right. So terminate, that's the ways you could terminate an easement. Let me see, I put that in the notes, yes. And encroachments, let's highlight that now. Even though I gave you that definition already, let's do the highlight now in the book. When all or part of a fence, driveway, or other installation illegally extends beyond the land of its owner, that is an encroachment. And they got a little interesting note here. Encroachments that are long-standing for a period of 30 years, they may give rise to easements by prescription. If you don't do nothing about it, whether it's giving the person permission or getting them to remove whatever they built that encroaches your territory. I was getting a listing several years ago in Linden where this the lady had a weird shaped lot. It wrapped around two properties on a corner. It was a weird shaped lot. But either way, the neighbor on her right built a big cinder block lot. However, we did a survey and we found out that that garage, a quarter of it was on her property. I was like, you're going to have a bit of a problem selling this. You're going to need to address that issue first. So you're going to need to get the neighbors to either tear down their garage or part of it, make their garage shorter or smaller or whatever. Or you could sell them that portion of the land that it's sitting on. And this way it doesn't bother you, doesn't bother them, but you got to replot your lot. So it shows that that piece of property is now part of theirs where the garage is sitting on. Or you give them permission to have it there and it remains your property even though there's a garage on it. They can't take ownership of your land if you gave them permission, even though they're using it. So, but in that case, you're still paying taxes on a piece of property that someone else is using. All right, you guys get these highlights?
Yeah, got it.
So deed restrictions are restrictions placed in deeds by private parties, not by governments. Governments have their own powers on how they could restrict your use of your property. These restrictive clauses added to deeds are added to deeds when a property is conveyed. They're established by the seller to restrict the future owner's use of a property, and they run with the land. They pass on from one owner to the next. And these restrictions last forever, unless the creator of the restriction, restrictive covenant, added a sunset clause that says that the restriction will go away after the certain period of time or upon the happening of a certain event. Types of estates based on restrictions placed in deeds are called fee determinable defeasible fee, or conditional fee. So let's do those highlights of those things. Let me see. So these restrictions last forever unless the creator of the restrictive covenant added a sunset clause that says the restriction will go away after a certain period of time or upon the happening of a certain event. Or a future owner asks them to remove it or pays them to. In rare cases, a court can remove it. That deed restriction. So you're just doing the highlights here, then you're writing next to deed restrictions, restrictive covenants. Those are a covenant, once again, is a legal promise. These are restrictive legal promises added to deeds. And what sort of estate and land is ownership forever, but that ownership is based on a restriction? It's called fee determinable, defeasible fee, or a conditional fee estate. It goes by those three names. Remember, that came from page 104 when we talked about the types of estates and land.
So, Victor, I don't know if this is a question or not. Why this is saying fee? What the meaning of fee?
Well, fee alone is a different type of estate altogether. Fee simple, and fee simple absolute is the highest form of ownership recognized by law.
Yeah. That's I remember. Fee simple fee. Yeah.
I mean, why do they put the term fee there? I have no idea. Never looked into it that much. I just studied it. This is what they call it, and leave it at that. You know.
Yeah.
The history. If you learn the history about it and why they call it that, why is the term fee used there? By all means, reach out to me. Let me know. But that hasn't really interested me that much.
Yeah, done.
All right. Everybody good?
I'm good as well.
All right. And that concludes this chapter. We'll do the key terms to review now. For chapter 6, there are 2 key terms to review for chapter 6. And before we get into them, on key terms 1, we're going to have to make some modifications on the right-hand side of the page to the explanations. For instance, letter A under key terms 1, letter A, where it says ownership lasting indefinitely, cross out the word indefinitely and write forever or a lifetime. Forever or a lifetime.
Okay, done.
All right, and then next to letter E. At the end of letter E, right, based on a restriction. Based on a restriction. Where it says ownership as long as. It's based on a restriction. That's what as long as means, as long as that restriction's not violated.
Mm-hmm.
And then just underneath that, we're letter F, where it says amount of ownership, cross out of ownership so that it reads amount or kind of interest in real property. amount or kind of interest in real property. So you're crossing out of ownership and you're writing or kind of interest in real property. Write small.
Yeah. Kind of interest in real property.
Or kind of interest in real property. And once you got that, everybody got that?
Mm-hmm.
Okay. Go to key terms 2 on the next page. Next to letter D. By letter D, where it says, notice that a lien may be filed. Cross out the word lien and wrote notice and then write legal action. So it says, notice that legal action may be filed. So you're crossing out the word lien or a lien. So it says, notice that legal action may be filed. And you can write foreclosure after that too. That legal action would be foreclosure. So put that foreclosure in a bracket.
That is the lease pendants?
Yeah. Yeah. So notice that legal action may be filed and then put foreclosure in a bracket there. And once you're done with that, go down to letter J in key terms 2 and cross out the word and write the word may. Third party who may gain eventual ownership.
Yeah.
Then go down to letter L. You're not crossing out anything. You're just trying to write above the first word because this word goes before it. Write the word possible so that it would read possible future interest of an owner. Okay, now once we got all that, let's go and do the key terms to review. Number 1. Ownership lasting forever or a lifetime.
That is the freehold estate?
It is a freehold estate. It's describing the whole category of ownership. 16 is A. It's the whole category. Remember, there's 2 categories of estates and land. There's the freehold, which is the ownership. It describes ownership that lasts forever or a lifetime. Permanent right to use another's land.
Easement?
It's an easement. 6 is B. Husband's right in the wife's property.
Husband.
Where?
No, husband's right in
Courtesy.
Oh, wait, courtesy.
Because courteous to women, that is the husband's right in the wife's property. Correct. 3 is C. Civil right to use part of an adjacent parcel.
Easement, apartment.
Easement, appurtenant. 7 is D. Ownership, as long as based on a restriction. So ownership based on a restriction. It usually has the word as written in there.
Easement by prescription.
I'm sorry?
Isn't it easement by prescription?
No, it's
a fee determinable.
It's not an easement, it's fee determinable. 14 is E. As long as you don't violate the restriction, you remain the owner. So it's a type of ownership based on a restriction that is a fee determinable estate. 14 is E, as in Edward. Amount or kind of interest in real property.
Amount,
kind of interest one would have in real property is called
estate in land.
An estate in land. 13 is F. A right to use for a right used for utility lines on another's land. A right.
Easement in gross.
In gross. 10 is G. A right of access to a landlocked parcel for the purpose of ingress and egress.
It's a landlocked in parcel right of access to landlocked parcels. Is this easement by necessity?
Yes. It is H, easement by necessity, when it's necessary to cross over your neighbor's property to gain access to yours because it's landlocked. Correct. So 8 was H. Wife's right in her husband's property.
Dower.
Dower. Doe is a deer, female deer. Dower begins with a doe, and a doe is a deer, female deer. That's the wife's right, the female's right. 5 is I. A right sometimes acquired through usage. That's the only way it can be acquired. When you use somebody's property for a long enough period of time.
Easement by prescription.
Yes, it is. 9 is J. Transfer by sale or gift. Transfer by sale or gift.
Convey.
To convey. 2 is K. Property that benefits from an easement. Who benefits from an easement? You guys should be able to get this without even looking. Try to formulate an answer in your head without even looking at the answer options.
The dominant estate.
The dominant estate, correct. 4 is the dominant estate. Most complete form of ownership of land possible.
Fee simple.
Yep, it goes by 3 names. Fee simple, or fee simple absolute. 15 is M, as in Michael. Any easement, encroachment, etc. There are examples of what?
Encumbrance.
An encumbrance, correct. 12 is N. Placed against real estate by a worker who has not been paid.
Construction. Something leads. What is?
Construction lien.
There you go. I was expecting you to get that really quick right off the bat. 1 is construction lien. Okay. Building intruding on another's land.
Encroachment.
It's an encroachment. Correct. They're encroaching on your property. 11 is P. All right. Next up, key terms 2. Structure owned by 2 adjoining landowners.
Party wall.
It's a party wall, correct. 9 is A. A claim against all the property that somebody owns. Here, let me correct that. Actually, we could write that, we could clarify that definition, that term, by saying financial claim against all property someone owns.
General lien.
A general lien is B. A claim against one parcel of real estate only.
Say that one more time. It cut out.
Sure. A claim against one parcel of real estate. A financial claim against one parcel of real estate.
A specific lien.
A specific lien. 14 is C. A notice that legal action may be filed. That legal action being foreclosure.
Lis pendens.
It is a lis pendens. 7 is D. Lender's claim against real estate.
Oh, mortgage lien.
A mortgage lien. 8 is E. Temporary permission.
License.
It is a license. 4 is F. The right to use and possess for a limited period of time.
Limited time, leasehold.
It's a leasehold estate. 3 is G. Property taxes are 1.
Priority.
Property taxes are what, an example of what?
Involuntary lien.
An involuntary lien. 2 is H. The order in which liens are paid. There you go, Victoria.
Priority.
According to their priority. Where the heck is that? 10 is I. Third party who may gain eventual ownership.
Remainder man.
Remainder man.
A remainder man. 11 is J. The tract over which an easement runs.
Servient estate.
The servient estate. It's the tract of land over which the easement runs, where somebody's walking all over and you're serving it up on a platter. You're the servient estate. 13 is K. Possible future interest of an owner.
Life estate.
Visionary interest.
I can see where you're coming from with the life estate, but that's not what they're looking for. It's a reversionary interest. Someone said that. 12 is L. Adding successive periods of usage. Tacking. You tack on one person's time to that of another to reach the prescriptive period with an easement by prescription, right? So 15 is M, as in Michael. Complete ownership until someone's death.
Lien.
No. Life estate.
Life estate.
Life estate. You have complete ownership of that property until you die. So that's a life estate. 6 is N. Financial claim against real estate.
A lien.
A lien. 5 is O. Mortgage or equity loan, for example. Those are voluntary liens. You went out of your way to get them. Correct. And that concludes chapter 6.